Does the American with Disabilities Act deal or protect alcoholics and drug abusers or drug addicts?
It will not protect somebody if they are a current drug addict or a current alcoholic.
Okay.
It will only protect them if they're rehabilitated. Now that same protection was available under our state law, because we're a very progressive state. So under the Fair Employment and Housing Act, we had that. For an employer, it's a little bit of a tricky thing, because a person is a current drug user right up until the moment they say, I'd like to go into a rehab program. And the minute they say that, they're a rehabilitated drug addict, and the employer has to accommodate. They have to let them go into that drug rehab program. Under the state act, you can only kind of pull that trick once.
I see.
But you can pull it once because the act was, both acts and our consciousness in this country right now is to try to encourage people to get off of drugs, to get off of alcohol. So for anybody who's in that kind of a situation, yes, you can gain the protection of the Americans with Disabilities Act and of our state law, but go into a rehab program right away.
Does an employer have, let's assume that an employer receives two applications for the same position. One is with some sort of disability, the other one is a healthy person. Does the employer have to hire the person with disability?
They don't have to. This is the procedure they have to go through. They have to take that disabled person and they have to factor in a reasonable accommodation. Then they have to take the able-bodied person. And at that point, they judge which one of them is more qualified. So let's say you have a blind person, and let's say that they require a reader. And you factor that reader in, an extra employee to read all of their material to them. That's not the only accommodation that blind people can use. There's a lot of machines out there that make it unnecessary. But let's say they even have a reader, because that would be a reasonable accommodation. If that blind person with the reader can be more productive and has better qualifications than the sighted person has, then you'd have to hire the blind person. On the other hand, if with the reader, that blind person is not better qualified, the employer can go ahead and they can hire the sighted person. So that's the analysis the employer has to do. You're not required to hire a disabled person. You're just required to factor in the reasonable accommodation.
Can the employer use the economics of the whole matter in deciding at which person to hire?
They can use the economics so long as they factor out at that point the cost of the reasonable accommodation. They're only allowed to consider the cost of a reasonable accommodation when it is an undue hardship. That's the only consideration they can give to the cost. If it is such a hardship that it would make the profitability of a particular site negligible, or it would be no longer worth remaining at that particular site, then they can say, I'm not going to hire you. And that used to happen with like ramping, but it doesn't happen with just a reader.
Well, when you say a reader, is that a machine, or are you talking about
if you had to hire an additional person?
Well, let's just be. I'm an employer. I'm looking for a certain position. I've got a blind person that is going to come in, and he's going to cost me $30,000 a year, and hiring a reader with him is going to be $20,000 a year. I'm looking at $50,000 a year, all inclusive. Let's assume, versus another person that can do the same job for $30,000 only.
Okay.
Am I obliged to? Am I obligated to hire the blind person?
You may be if they're more qualified. Now I happen to know that you have a relatively small law firm. You're not Pillsbury, Madison, Sutro with hundreds and hundreds of lawyers. Okay.
Nothing.
That is and that's what reasonable accommodation looks at. How big are you? Can you afford that extra $20,000, or would you say, if I have to hire 2 employees, I truly can't get by. I just simply cannot afford that. That hurts the profitability of my business so much. I really can't. And that may be possible for a small office. We're a very small office. That's a possibility that if we had to hire 2 people, we just simply couldn't do it. On the other hand, if you're, Gibson, Dunn and Crutcher or Ropers Majeski, and you have hundreds of attorneys, yes, you have to go ahead and pay for that extra person, even though it's almost twice as much money.
Why do I suspect that a lot of employers don't like this kind of program?
They don't, and yet I think as they get more and more disabled people, they will feel better about it. Also, let me tell you that the average cost of a reasonable accommodation so far since the Act has been put into effect has been less than $500.
A year?
Usually, total.
Oh, so it's negligible.
Exactly. At first you think of an accommodation like a reader, which they may have to go all the way up to a reader, but then you think, well, what machines are available? And you'd be amazed at the very simple accommodations that let people do their job. instead of ramping, there was a case where there was a bank that was, they were asked, to accommodate for a teller that was in a wheelchair. So the question was, do we have to lower all of the teller's desks? That could be pretty expensive to put in a front desk that's low. The answer was no, you need to use a clipboard so that they can keep handing back and forth the documents. Sometimes the accommodation is, $2 worth of creativity.
Yeah. So the economic hardship is rather an objective test at the time, and the employer has the burden of proving that this was such a hardship on them that they could not accommodate that particular disabled person. Is that about right?
Yes, and I would say that normally some creativity will avoid an undue hardship.
What is the remedies for someone? I'm a blind person. I go to Pillsbury Madison and Sutro, and this is a free plug for them. And I tell them I need a reader, and they can afford me and can afford the reader, but they refuse to hire me even though my qualifications are at least equal to the other person they eventually hired. What are my remedies?
Okay. You have remedies under the Americans with Disabilities Act. You also have some remedies under the Fair Employment and Housing Act, our state act. But under the Americans with Disabilities Act, you have a right to all of your wage loss, all of your benefit loss. And that means you may be looking for a job for a while. Well, if you'd gotten this job, you would have had, wages and benefits. You have a right to your emotional distress. You have a right to punitive damages, and you have a right to attorney's fees. And the cap is $500,000 under the federal act. There is no cap under the state act, so it can be more than that.
So one would think that he or she should go through a state court rather than a federal court, and actually state law.
You can bring your state and federal claims either in state court or federal court. You're not forced to that choice. But the better remedies are probably going to be available under the state.
Right. But the burden of proof is on the disabled person, obviously, to show that this actually was a discriminatory act, and it's not as simple. However, Diane, why don't you tell our viewers your phone number in case they do have an employment problem and they would like to reach you. Your phone number is?
971-9993, and it's in the 408 area.
971-9993. Diane Ritchie is our guest, an employment rights attorney. Quite capable, I might add. We talked a little bit about the accommodation needed by an employer. Is there anything else you want to add? Does the employer have to go the extra yard, or are there any limitations to these accommodations?
When I'm advising employers, what I said about creativity is what I'm advising them. Find an accommodation that you can afford. I had a client who was a plaintiff. She had a short-term memory loss. She had dyslexia. All she needed was a spell checker and a grammar checker and the ability to take notes. And when the information was coming in too quick, she needed a little dictaphone tape recorder. That's all that it took to accommodate. So you, as an employer, you need to grant a reasonable accommodation. But you don't have to grant the accommodation that the employee asks. You can use your creativity and grant something else that's a little more economical for you. And it probably is going to require you to either use creativity, and when you've exhausted that, you're going to have to get a hold of some experts. But more and more experts are coming into this field who can give you advice on how to reasonably accommodate.
Let me ask you somewhat of a complex question, I think. Someone is working for ABC Corporation and for whatever reason got some form of disability through an atrophy of muscles or some kind of a disease whereby their disability is now permanent. They go on permanent disability, then they come back and they can do some other work within the company. What is the employer's obligations towards that person?
The employer is not obligated to give a different job. You always judge a disabled person as to how they're able to perform the essential job duties. And if they have a certain job and they can perform those essential job duties, you're going to have to be put to this test of reasonably accommodating. If they can no longer perform the essential job duties, you don't need to accommodate them, which points out a preventative thing that employers can do. You should write down what your job descriptions are, what they actually require, because it's going to protect you so that you're able to
justify a
decision.
Right.
Exactly. There's only been one case that's been decided under the Americans with Disabilities Act so far, and it was a case where the employer was found not to have reasonably accommodated an employee who had an inoperable cancer of the brain. And he was the chief of security, and they felt that with short-term memory loss, with the inability to drive, that he simply was no longer able to perform his job. His doctor said, no, he can't perform his job. He can't perform non-essential job duties like driving. He's going to have somebody else drive him, but it's not a large part of his job. And if he uses things like writing notes, recording things, he's going to be able to perform his job. And so that company was found liable. Now, it was only a $300,000 verdict against them, but it's the very first case to come out, and that employer could have avoided this entire problem with some creativity.
And that seems to be an interesting case. I mean, brain cancer, you would think that there will be a significant disability, but the court found no, that he can actually perform. Interesting. Let's talk a little bit about pre-employment medical exams. Are they allowed by employers nowadays, and what's the status of the law on this?
You can have a pre-employment medical exam. You cannot have a medical exam until after you've made an offer of employment. And the reason for that is because it would be almost impossible to ever be sued if you were able to require an applicant to go through a medical examination. You just say, well, gee, we decided not to make you an offer. So once you've given them an offer, you do a medical exam, and what the employer should be thinking about is, this medical exam is only to see how we can accommodate, not to try to eliminate this employee, because by then you are going to be accommodating.
Yeah,
so
well,
you can't have pre-offer medical exams.
On the other hand, why the medical exam if you've already made the offer? You know,
it probably makes it so a lot of employers won't bother with them. But if they do want to accommodate, it will be a useful thing for them, because then they have an expert to say, well, this is a reasonable accommodation, instead of just listening to what the employee is asking for. You don't have to grant the specific accommodation that's requested.
Okay. Now give me some more specific acts of discrimination that violates the American with Disabilities Act.
I can give you some from my cases. I had a case where the employer had a high-level manager who did suffer an aneurysm. And so all of his short-term memory was gone. But he had long-term memory, and he'd done the job for a long time. That particular employer looked at the doctor's recommendation of difficulty in learning, task, please allow longer if the task is new. And instead of keeping him in the same job once he came back from medical leave, they switched him every 2 weeks to a new job and eventually terminated. And they said, gee, see how hard we're trying to accommodate. Now, they did that under the old law, the Fair Employment and Housing Act. I don't think that they would, especially with the consciousness that's been raised, I don't think they could succeed in trying to justify their actions under the Americans with Disabilities Act.
This case hasn't been tried or settled yet, has it?
No.
Okay. Well, good luck. By the way, Diane Ritchie is our guest. She is a lawyer with the Employment Rights Lawyers of San Jose, and her phone number is 971-9993.
Exactly.
All right. Give her a call if you have a problem. Or if you're an employer and need advice on how to deal with employees with disabilities, I think that is probably an extremely important issue for employers, just as much as employees need to know their rights. Employers need to know what they should do to accommodate people with disabilities. If an employee believes their rights under the ADA have been violated under the law, what do they have to prove?
They have to prove that they are disabled and that they can perform the essential job duties. That's really all they need to do if the employer takes an adverse action. If the employer fails to hire them, if the employer fails to give them a promotion, if the employer terminates them. Another way of doing it completely is to just prove that the employer refused to give a reasonable accommodation. Either of those will be a way of proving discrimination.
So they have to prove basically that the employer was aware of their disability.
Right.
Must the employee inform them of their disability, especially if they are mentally disabled?
If it's not a disability that is immediately apparent, like you're in a wheelchair, anybody can tell, or you're blind and you've got a cane, you do have to inform the employer that you're disabled, because unless the employer knows that you're disabled, they don't have a duty to accommodate. And that is very difficult a lot of times with mental disabilities. There's such a strong degree of prejudice against people who do have mental disabilities, like whether it's retardation or schizophrenia, that employees are really reluctant to tell their employer. But until they tell their employer, they don't have a right to a reasonable accommodation. And if their employer doesn't know they have the disability, I can't prove that they've been discriminated against on the basis of it.
I would assume that knowledge can be through a third party too, right? I mean, if someone else tells the employer, then the employer's duties are still there.
As long as they know.
Right. Other than coming to the office of Diane Ritchie and tell you that I have been discriminated against by my employer because of my disability, what can an employee do if he or she feel like they have been discriminated against because of their disability?
They should get into the EEOC, the Equal Employment Opportunity Commission, within 300 days of the date of the discrimination and file a complaint.
Repeat that, because this is so important. Slowly.
Okay. They must go to the Equal Employment Opportunity Commission within 300 days of the date of the discrimination. The EEOC does not charge anything, and you are required to exhaust your administrative remedies. You can also go to the Department of Fair Employment and Housing, our state agency, within 1 year of the date of the discrimination and protect your state remedies. You can go to either agency. They have concurrent jurisdiction. I always recommend the EEOC, and the reason I recommend the EEOC is, number one, our local office is a better organized office, but number two, the EEOC can provide an attorney to argue your case, to bring it in court. And out of every 100 cases, 3 of them, the agency finds that there is discrimination. And out of the 3 cases they find there's discrimination, about 25% of those, they will provide counsel and argue it. And the reason it's only 25% is once the EEOC says, we found that there is discrimination and we're about to take the case, most of the cases settle. So the Department of Fair Employment and Housing doesn't have that ability. They don't provide counsel. They don't argue the cases.
Okay. I just happen to know the phone number for the DFEH, the Department of Fair Employment and Housing, and that's 277-1264, I believe.